Joining me now to talk about this case is Daryl Cohen and Ashley McMahan. Both are criminal defense attorneys and former prosecutors. All right, thank you guys for being with me. Ashley, thank you for coming back. Daryl. All right, so am I the only one that was thinking, what the hell are you thinking, Brian Frost, for letting her go up there and actually say what she said? The disrespect in her body language, is that not something that we tell our clients? Ashley.
Even the judge mentioned that they had spoken about this previously in chambers. I think her attorney probably had a long conversation with her prior to this where, you know, he's doing everything he can to wrangle her in. And honestly, from the blank look on her face and from the disrespect she was showing the judge by sitting down and not standing when he's speaking to her and speaking back in those outbursts, I don't know that everything is really sinking in for her right now.
Yeah, it seemed like she didn't really understand what she was charged with, right?
Exactly.
Okay, Daryl, why didn't the defense, her attorney, Brian Frost, bring anybody from the gallery? I mean, you saw the gallery. There were family members there. They were crying. Why was nobody testifying to her character, that she's been beaten, or her family history or upbringing? Why? Mitigating.
Let's just say that he did something that I would not have done. What I would have done, I would have had family members. I would have prepped her, asked for 5 or 10 minutes, Your Honor, can I speak with my client?
Yeah.
Let her know you stand, you show respect, you're sad for what happened to your infant. You have family members saying she's a good person, but take a look at her before. She had a black eye. She was beaten by him. She's a battered woman. They brought up nothing, and I'm very surprised, and I'm quite frankly disappointed.
Disappointed, and she might have actually gotten a lot less, Ashley.
Yes.
The judge gave her 15 years, and the state was asking for 30. She said nothing. She showed no remorse. She still was proclaiming her innocence. Why didn't he max her?
Here's my thought. I'm thinking that this is the fault of her attorney, really, because these are conversations that you have from the beginning of the trial, right?
Right.
From the moment those jurors walk into that courtroom, you say you are standing up, you are showing respect to the judge, you are looking sympathetic because you are sitting next to, McNabb, who does not appear sympathetic at all.
Yeah.
You know, that's kind of really the only card you've got to play here.
Yeah.
And the fact that didn't go through. I think Judge Ott is really hoping here that she's going to preserve her right. I mean, he went over her right to appeal and preserve her right to appeal, and that she's going to go through with that. And I'm betting that, the only argument she's really going to have is ineffective assistance of counsel.
The usual.
Which is exactly, we're very familiar with it.
We don't even get offended anymore, right?
Right.
We don't get offended any less.
Yes. I think it's the only time that you get a defense attorney to go in and testify on your behalf and say, yes, I did a bad job, and we're happy to say it because it gives our client another chance.
Yeah.
And I think that's probably the route that they're going with this one. I think that was what Judge Ott was thinking.
I agree. So the closing arguments went in this order. You had McNabb's attorney, Carter, go first. You had Courtney Bell's attorney, Brian Frost, go second. And it progressively got better and better. And then Layla Zahn blew everybody out the water. She had the last closing argument to make. She addressed both of the attorneys and the possible reasonable doubt that they were raising, and just was fearless. And we do have a clip, if we could play that real quick for our viewers.
This charge is not that one singular bad decision, like what was alleged by the defense was, well, if you leave your kids, out in an ocean where there's sharks swimming around and they're being fed and there's blood in the water, yeah, that's a singular action. We're looking at a cumulative 14 days of this child's life. Everybody, like Mr. Frost said, everybody can make a mistake. I mean, my goodness, what if you accidentally left a candle burning and it fell over on the child and the child burned? I mean, there are going to be situations that are just accidents that nobody could foresee. But that's not what this is. I mean, we're talking about for 14 days what's happening to baby Kalia. I mean, let's actually talk about what baby Kalia's life was for 14 days. And the only person who really had control over that is Courtney Bell. McNabb, anytime he sees Tim Bell, he runs like a chicken, like a coward. Guilty conscience, once again. Poor girl's walking around with black eyes the day that her baby's missing. You saw it in the trailer. Probably another reason he runs. What a coward. Beats up on women.
What a coward, beats up on women. I mean, she was not letting up. She was really attacking Christopher McNabb. Now, as a former prosecutor, and both of you are as well, you wanted to learn your style in court. You were able to learn that style in court. And I didn't want to emulate anybody because I didn't want to come off disingenuous. I would want to be like Layla Zahn, right?
Absolutely. She went for the jugular on this one. And obviously her closing argument really resonated with Judge Ott.
Yeah.
I mean, you heard her say in her closing, you know, it's like leaving a baby in the ocean with sharks swarming around it. And then you heard Judge Ott reiterate something just like that, talking about, you know, putting a baby in the same room as a rattlesnake. So her argument really hit home. And I think she was the clear winner in this on style, I mean, she really let everybody have it in this trial.
Yeah, and Daryl, generally the state is kind of always the winner in terms of like resources and access, and we're always as defense attorneys kind of, you know, climbing up that hill, right?
The hill that we never quite reached the crest of, yes.
But we just saw Layla Zahn, just a clip, but she had visuals, and I'm a visual learner. And as a juror, I would have wanted the defense to have some visual so that I can make sense of everything and maybe connect the dots better. What did you think?
I thought that our prosecutor, I thought Layla Zahn was incredible. She closed every door. She made every door impassable. So she surrounded him. Now the defense, in my view, should have personalized both of their clients, should have made them more human. They didn't do any of that. I don't understand why, but every lawyer has his or her own idea of what his or her defense should be. I would have absolutely, especially during the sentencing phase, brought family members, brought people there to make people feel sorry for her, at least in that instance.
Yeah. They missed that opportunity. It was such a missed opportunity.
Body language said everything. There was no body language that was positive for the defense. It was all positive for the prosecution. If it's negative for the defense, it makes it positive for the prosecution. The body language just was awful.
Yeah, I agree. Daryl Cohen, Ashley McMahan, thank you so much for the insight. All right, we're going to take a quick break. Stick around. There's still more to come right here on CourtTV Live.
A guy who was very competitive. I mean, he played for 10 years in the NFL, had an immense amount of success, had the ultimate American dream, felt like he had it all.
Kellen Winslow Jr. pleaded not guilty to kidnapping two homeless women. The former NFL player reportedly lured them into his Hummer and raped them.
If he's convicted on all counts, he's facing multiple life sentences.
The allegation is he sexually assaulted the alleged victims at the same time period.
He threatened to kill her. He told her that if she screamed, he would murder her.
The notoriety, the money, his wealth and his fame, all of that is at risk now.
It's a money grab, unfortunately. That's the society we live in now.
We're talking about a kidnapping and a forcible rape of strangers, of older women.
Because I don't care who's going to watch, I'm going to kill you. I told him to stop.
Her credibility is suspect. Mr. Winslow has every interest in attempting to prevent and dissuade these victims from testifying.
You immediately knew that this was something that people were going to pay attention to.
Any words today about court?
No, all the facts will come out.
It appears as though he was attempting to be able to destroy potential evidence.
I just thought he was going to shoot me or something. I don't know.
Winslow Jr. could face life in prison.
He knows walking in and out of courtroom, the eyes are on him.
To the people that know me out there, they know who I am, and I'm an innocent guy. I'm an innocent man.
Welcome back to CourtTV Live. I'm Yodite Tewolde. Chris McNabb and Courtney Bell were found guilty in the death of their 2-week-old daughter. We covered this trial from gavel to gavel. Here's a recap of the road to justice for baby Kalia.
My 2-week-old is not in her sleeper. Her passy on the floor.
Man, I want my kid, man.
Did you actually see him leave?
Yes.
To go look for the baby?
Y'all got the wrong idea.
Courtney was having a hard time. She wanted to get high.
That baby girl deserved more than not a duffel bag in the woods.
Do you have any idea what could have caused that sort of trauma?
A very hard force.
That guy that his baby was found dead is in the Chevron.
I could hear people in the car.
He jumped out of the car, but I told him to get out of the car also.
And I heard someone tell Chris to run.
And he goes, the
cops are on my trail.
They abandoned them youngins yesterday.
The evidence will show that just 14 days later, her father, Christopher Michael McNabb, ended her life so abruptly.
Count 1, murder in the 2nd degree. Count 2, cruelty to children in the 2nd degree. And count 3, contributing to the deprivation of a minor.
And one of the most interesting things was how the bodies were disposed of. Wrapped in items, Casey, blanket, trash bags. This young lady in the duffel bag, and they were all disposed of in a wooded area close to home.
I feel like the story's changed.
Mr. McNabb's house smoking. What were y'all smoking?
Man.
Smoked a blunt before we left.
Yes, he had on some blue camouflage shorts.
And did you find blue camouflage boxer shorts inside of the drawstring bag with baby Kalia?
We did.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time.
Y'all know I didn't do this.
If you ever find out who did them, they deserve to be under the jail.
Okay. So they ought to get the maximum sentence.
Most definitely.
Okay. Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty.
Wow, so many compelling moments there. Okay, so joining me now, right now, is my colleague Julie Grant to talk about the verdict. Julie, we were talking about Layla Zahn. Of course, she was the star for us. She made me forget about the two other closing arguments.
Right.
Her style, we're both former prosecutors. Her style is something that I think all prosecutors should try and emulate because she was fearless.
I agree.
She confronted McNabb to his face, called him out, and I thought that that was effective. What did you think? What were your highlights of Layla Zahn's closing arguments?
Oh, I agree with you, Yodite. Yes, you can see why Layla Zahn is the district attorney in that county.
Yeah.
She was a fearless advocate, and I loved your words earlier today when I was watching you on the set here, and you said she was forceful, fearless. Yes, yes. That's what an advocate should be.
Yeah.
Just like that. And again, and you could tell she's speaking from her authentic voice and from a place of authenticity, from a place of passion.
Yes.
You could just see the connection that she had to this case. I mean, this case made her mad. And you could see how mad she was.
Yeah.
And when she delivered those arguments to the jury, she was quite compelling, quite fascinating to watch, and really engaging. And of course, that style doesn't work for everyone. All the attorneys had their own style. And I thought each of them has a style that really worked for them. Like Anthony Carter, he's a little more conversational. He sounds a little more like a guy you might have at the breakfast table, and he's just telling you what happened, sharing the story with you. And again, I thought he really scored a lot of points with the jury when at one point he said, Layla Zahn is one of the best closers I've ever seen. She's going to get up here and do an awesome job. And he was kind of self-deprecating. He said, and I'm fumbling over my words here. And I
Made
think
you really connect with them at
it
that point,
did, right?
Yeah.
Very likable. I thought they all came off as likable in certain ways.
Which was important because their clients were so not likable.
Yes.
You know,
yes,
it's
you're
hard to like McNabb. It's hard to like Courtney, especially that moment, that clip that we keep seeing with her crying and saying, y'all know I didn't do this. I didn't even feel bad for her. I felt angry because you're still talking about you. They only care about themselves. And so what did you think about the sentencing? And I'm asking you about that only because I think that the defense attorneys failed their clients, because we have conversations. You weren't a defense attorney, but could you imagine defending somebody and getting into the sentencing phase? Would you not prep your client in terms of what to say? If it may not be genuine, you may not show remorse, but as a former prosecutor, you'd be happy to hear McNabb say what he said during sentencing, right?
Oh, absolutely. Absolutely. And and perhaps they did. And you know so well, you've done so much defense work, you know. Sometimes you can prep them and tell them and instruct them, but then they want to do what they want to do, want to say what they want to say. And so certainly I think the big question all along when we've seen tears coming from these two defendants, the question has been, are these real authentic tears coming from parents who are devastated about the loss of their baby? Or are they crocodile tears? Are they tears to try to get sympathy from the jury or from the judge?
And again, something I think also to be mindful of when you're a practicing attorney and you go before the same judges over and over again in courtrooms, you have a general idea of what the judge is going to do. They all, I'm sure, had a good guess because with their clients, they're going to play out every scenario. Okay, if we decide to plead guilty, if we decide to take the offer the prosecutor has on the table for us, what might the judge give if you're found guilty? So I'm sure they had these conversations. And the way it worked out, I know with what Brian Frost said, he felt like this was a real win. And I would agree with him because he said that the plea offer was 25 years for his client, Courtney Bell. So they did better by taking this case to trial.
Now imagine if she showed some remorse. She might have gotten less than 15 years.
Maybe.
Julie Grant, thank you so much. All right, we're going to take a quick break. But when we come back, we're taking you to San Diego for a preview of our next big trial, California versus Kellen Winslow II. The rape and sexual misconduct trial against NFL star Kellen Winslow II is set to begin on Monday. And of course, CourtTV will be there to give you live, gavel-to-gavel coverage of what's to be expected in this very high-profile case. CourtTV crime and justice reporter Ted Rowlands is in San Diego, where jury selection is underway.
Good morning, Yodite. Very productive day here in San Diego. Day 2 of jury selection, and there are now 84 prospective jurors that have been pre-qualified. These are jurors that have said, yes, they are available until June 21st. And yes, the charges against Kellen Winslow, especially the rape charges, aren't too much for them to handle. And thirdly, the other qualifying part of the questionnaire that they filled out was the pretrial publicity. Was what you've heard about this case too much for you to be fair and impartial? These 84 have cleared that hurdle, and now they will be brought back into the courthouse here in the North County San Diego courthouse on Thursday. And on Thursday, that's when we'll see the full voir dire from the attorneys. The attorneys will have opportunities to ask jurors individually different questions about their history, what they know about sexual assault. Do they have family members who have been victims of sexual assault? What about sports teams? Kellen Winslow is a sports legend. His father is a Hall of Famer. Those are the types of questions we're expecting from both sides so that both sides can figure out who they want to sit on this jury. That jury is expected to be seated by Friday about noon, and then opening statements are scheduled for Monday morning. Kellen Winslow is facing 12 separate charges, and it'll be up to this jury that's picked this week to determine his guilt or innocence. Yodite, back to you.
All right, there was a pretrial hearing in the Winslow case last month in which the judge went over several motions filed by the state and defense. The first was about excluding certain witnesses. Let's listen.
Now we'll move ahead to then Jane Doe number 2, which is from the May 13th incident and form the basis for count 5 and 6, just so we know we're all on the same page. Do you have any fresh complaint evidence that you intend to present with respect to her?
I do, Your Honor.
Okay, and tell me about that.
Thank you. There is a identified witness by the name of Christina Garvey that is referred to in the discovery. She is a friend of Jane Doe number 2's, and she was the first person to whom Jane Doe number 2 confided. At the time, it was actually the early morning hours after the sexual assault that Mr. Winslow committed. She, in fact, spoke with Jane Doe number 2 and was able to have Jane Doe number 2 make a statement regarding the rape, because she noticed that Jane Doe number 2 was still very stressed, was not acting herself, and was, the people would argue, under the continuing excitement of the exciting event. So it may come in both as fresh complaint, but then also as a potential spontaneous statement, depending upon the evidence that would be presented at trial. So the people would be seeking to introduce that statement through Christina Garvey, as well as the same arguments that the people have made under with respect to Jane Doe number 1 and the subsequent statements to law enforcement that were then made that same morning, as well as to the detectives in their follow-up interviews.
Okay, so you're offering under the spontaneous statement exception under 1240?
Yes, Your Honor.
All right, and then well, don't we have to have a hearing on that then? Because there has to be sufficient foundation that's laid to show that the statements were made under distress and excitement of the event. And there's a number of factors the court will consider, including the timing between the event and the statement and her state of mind, because the issue is whether or not the statements were made under the stress and excitement of the event, rather after time to pause and reflect and have the ability to contrive or have thoughtful reflection about the statement. So do you want to bring her in and have a 402 hearing or go based what's on the transcript?
Well, Your Honor, what I would ask is that the court reserve on that issue until the testimony has taken place, and then the people can, of course, address whether or not we believe the foundation has been laid to introduce it for its truth under that exception.
And then, I don't know, Ms. Barr, Mr. Carlos, who's handling this? Ms. Barr, any objection to proceeding under those, under that procedure? In other words, we'll see if sufficient foundation has been laid. And of course, Mr. Owens would not be allowed to refer to that statement in his opening because we don't know if it's going to be admissible or not. But are you okay with just seeing if sufficient foundation can be laid?
Following a 402 hearing?
No, without a 402 hearing.
Yes, Your Honor.
Okay, all right. So then I'll reserve on the statement to Christina Garvey from Jane Doe number 2 with respects to count 5 and 6. If he can lay sufficient foundation for the spontaneous statement, it'll come in. But we'll just wait and hear what she says. And the court will order, Mr. Owen, that you can't refer to that statement in your opening statement because at this point, we don't know if it's going to come in or not.
And just to clarify, though, Your Honor, the people are seeking that the court allow reference to the fact that the statement was made and the circumstances under which the statement was made under the fresh complaint doctrine, just not the actual substance of what Jane Doe 2 said to Christina Garvey in opening statement, perhaps, but the people ultimately believe that that will become relevant and admissible, and the proper foundation will be laid once Jane Doe 2 has testified.
Okay. All right. So you are offering that under the fresh complaint doctrine, correct?
Correct.
Okay. Any objection to that, then? It is allowable under People versus Burton at 55 Cal 2nd 328, and it is just the fact that the disclosure is made and it's admissible only for the non-hearsay purpose of establishing that the complaint was made without great detail. I mean, there has to be enough detail that it relates to the charged crime and is the defendant is the perpetrator, but other than that, the details can't come in. Burton allows sufficient details to relate to the charged crime. So do you want to be heard on whether or not it's admissible under the fresh complaint doctrine?
No, Your Honor, the only objection would be that it not...
You don't have to stand.
That the people not refer to it as the fresh complaint doctrine in opening.
Well,
I don't think I'm going to be using the term doctrine, Your Honor, but I think that the fact that it is either an outcry witness or a fresh complaint that was made, I think that people would be able to accurately characterize that.
Right. Well, that request is done. You can refer to that she made a fresh complaint to so-and-so, and certainly in closing you can do that. So that request is denied. I just don't refer to it as the doctrine.
I will not.
Okay. All right. So then that's, just to be clear then, with respect to Jane Doe number 2, the fact that the complaint was made will be allowed for the non-hearsay purpose under the fresh complaint doctrine in People versus Burton. Whether or not her statement qualifies as a statement that's made, a spontaneous statement, remains to be seen if sufficient foundation can be laid.
Okay, so we'll be playing more of that hearing throughout the day on Court TV Live. Before we go to break, we want to remind you to check out our CourtTV.com. You'll get the latest coverage of our current trials. You can also watch some of the most compelling trials of all time in our Trials on Demand section.
Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty. That's all 3 counts against Ms. Bell and all 8 counts against Mr. McNabb.
An hour and 5 minutes. That's how long it took a jury to convict Christopher McNabb and Courtney Bell in the murder of their 15-day-old daughter, Kalia. Both parents maintained their innocence, but their tears and defiant words did little to sway the judge during sentencing. It was a dramatic end to an already emotional trial. We'll break down the road to justice for baby Kalia. Plus, an NFL star accused of rape and sexual misconduct by 5 different women. The state calls Kellen Winslow II a serial sex offender. Winslow and his defense team call the allegations a money grab. We have a team in San Diego as jury selection ramps up in California versus Kellen Winslow II. Court TV Live starts now. Good morning and welcome to Court TV. I'm Yodite Tewolde. Chris McNabb and Courtney Bell were found guilty in the murder of their infant baby. The judge sentenced Bell to 15 years in prison with another 15 to serve on probation. The judge sentenced Christopher McNabb to life in prison without the possibility of parole. Court TV legal correspondent Chanley Painter joins me now in the studio.
Good morning.
Chanley, tell me what it was like in that moment when the verdict was read, what the reaction was like from the gallery.
It happened pretty quickly. I know you just showed the viewers how the judge presented it. There were no formalities, really. The defendants walked in. Courtney Bell turned around and told her family that she loved them right before the verdict, and then we all kind of got quiet and the judge read the verdict. It was over. He polled the jury, and then I guess the highlight was Christopher McNabb decided to speak up. As the jury was still in the courtroom, as they were leaving, he said, "It was a setup, I'm innocent," and so much so, Yodi, that the judge had to have him escorted out of the courtroom.
So he's still maintaining his innocence.
He
So
is,
clearly
very much.
disrespecting the verdict that the jury came back with in
Right.
65 minutes. They were convinced. What about the display that he made during the sentencing? He stood up and I don't mean to laugh at it, but you could see Anthony Carter like, no.
Right.
Clearly didn't have, maybe had a discussion with him about sentencing. Maybe he didn't. I don't know, but he took it upon himself, McNabb, to address the court, not about his remorse, not about his daughter, not about the abuse, but about a woman on the stand who testified that he masturbated in front of her. And this was a psychologist, right?
Right.
Who was supposed to be evaluating while he was in jail?
Him, yes.
Can you tell us about that?
In the jail. So apparently he was wearing what's called a turtle suit, which
Yeah.
is when prisoners are on suicide watch. They wear a certain suit. And she says that there was a glass wall between them. As she was writing down some things about him answering questions, he says, "Look up." And she looks up, and he's exposed himself, pulled his pants down, and masturbates to completion right in front of her.
To completion, which is completely opposite of what he said when he addressed this very situation. We have that clip.
Carter, do you have any evidence to offer in the way of mitigation?
I believe Mr. McNabb would like to address the court.
Okay, you may do so. You may stand up and address the court.
I'd just like the court to know, as well as everybody at home, since this is being broadcasted for whatever reasons, that I did have on a turtle suit and it velcros and it wasn't on properly and it didn't fit properly, and the velcros were not on good because they don't stick, because they've been used for so many years by so many different people, and I was not masturbating at all in front of her, period. The thing fell off when I stood up, and that was it. There was none of that, and I would have liked to have told her that, since she was the one making the accusation, since I'm pretty sure by the law states that I have a right to confront my witnesses who accuse me of doing wrong. So I felt like I wanted to say it in front of her, since she was the one up here slandering me. And that's all I got to say.
You sure you don't want to talk about the sentencing and all of that? That was the only thing you wanted to tell the court?
I mean, I haven't heard anything about a sentence. I was just commenting on that. I understand
for the charges. And I just wanted to know if you had anything you wanted to say to the court.
I mean, I got a lot to say. I got a lot to say, but I'm not going to be able to say half of it.
I don't know, because I don't know what you're going to say.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time. I feel like there was things that were allowed to be said that should have never been allowed to be said, that didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. So that doesn't make sense either. And, just to let the record show that I don't think I ever put my hands on her in front of those kids. And I just don't feel like just because somebody has domestic issues with the female in their life that they love, that they were just able to just say, "Oh, he don't love you," and all that stuff just in front of everybody or whatever, which doesn't matter. But I just don't understand how you find somebody guilty of doing something to a 15-day-old baby, because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it. I never would. I don't believe in it. I was beat as a child, and I don't agree with it at all. And I would never do it. I would never do this. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement, consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal.
It'll be filed.
On this case. I'm going to instruct Mr. Carter on behalf of you to file a motion for a new trial to make sure your rights are protected. If you wish to allege that Mr. Carter did not do an effective job, then we'll bring in another attorney to handle the appeal so that issue can be raised, and that's fine with Mr. Carter. He takes no offense.
I think he did an incredible job.
Well, that's fine. I'm just indicating to you that in order to claim your attorney at trial was ineffective or did not do a good job, you have to raise it at the earliest moment, which would be here.
I won't be filing anything against my attorney.
That's fine. I also want to inform you that if the case is appealed, if the Supreme Court of Georgia affirms your case, you have 4 years from that date that the affirmation is made in what they call a remitter. The case is sent back down here to file what is known as a writ of habeas corpus, claiming that your body is still being held illegally and unconstitutional. It has to be done within 4 years of that date. 4 years and 1 day, they would not listen to it. So do you understand that right also?
Yes, sir.
Any further rights I need to advise from anybody that you know about?
No, sir.
Okay, take Mr. McNabb on back.
So immediately after McNabb was sentenced to life in prison without parole, the judge moved right into sentencing for Courtney Bell.
Thank you. Does your client wish to make any statements?
I didn't do this.
Stand up.
Y'all know I didn't do this.
Ms. Bell, you and I had a conversation back in Chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder, it wasn't that you anticipated the murder, it wasn't that you planned the murder, any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature, have an appreciation of the outdoors, without appreciating the danger. Now, I'm sorry, but for you to go around chasing McNabb, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, I mean out everywhere. The mother bear, they're so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNabb over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNabb, is that, like most criminals, you have this version of what a good mama is that is so far from the norm that, you know, you go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I've known of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up and they don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. Well, let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Okay.
All right, so I'm going to bring back Chanley. Chanley, she just doesn't get it. She doesn't get it. She seems confused as to why she's being sentenced in the first place. And the judge made a reference to having discussed this with her. What is he talking about?
He's talking about last Wednesday. Remember, court started about an hour late. Last Wednesday, we were all wondering why, what's going on, what are they meeting about in chambers? Well, we learned that he was meeting with her. The day before, last Tuesday, when they showed the body cam footage, she really broke down emotionally in the courtroom in front of the jury, and to the point where the judge admonished her in front of everybody, said, keep it together, I'm not going to have this in my courtroom. Well, on Wednesday, last Wednesday, the autopsy photos were expected to be shown in the state's case in chief, and he wanted to meet with her early that morning to make sure, look, I will not stand for any sort of outburst. I'm not going to prejudice this jury in any way. You're welcome to step out of the courtroom while these photos are being shown, or keep your head down, but no emotional outburst again. So,
and it seems like it went further than that. Maybe in that meeting, they talked about the charges, because he said, when she said, I didn't do this in that tearful moment, he says, you created an environment that caused your children to be second and McNabb first. So it seems like he explained second-degree murder because she was still confused, because she almost implied that because she didn't know what happened to baby Kalia, that she should be not guilty, right? That's what it seemed like.
It does, because second-degree murder has the word murder in that, and she's not the one that actually killed the baby, so that's where she was a little confused. Under the statute, it's criminal negligence of cruelty to a child that led to the death of the child, not that you actually were the one that did the blunt force trauma on the baby. He was trying to explain that to her, and notably in her jailhouse confessions, or not, I call them confessions, but statements to police after she was arrested, she does admit in that her attorney had an issue with this, that she said, yes, I was negligent in that statement. And he's saying, look, she doesn't understand the definition here, Judge.
No, she understands. No, she understands.
Well, the jury agrees with you.
The jury definitely understood the charge clearly. 65 minutes. Thank you, Chanley. All right, the lead prosecutor in this case, District Attorney Layla Zahn, is going to be here on Court TV Live this afternoon. Stay tuned. You do not want to miss that. We'll be right back. Welcome back. I'm Yodite Tewolde. 5 days of trial, more than 30 witnesses, and dozens of hours of interrogation videos and evidence in the baby Kalia murder trial. All of that led to a lightning-fast verdict from the jury yesterday. Guilty on all counts for both Chris and Courtney. Joining me now to talk about all this is Ashley McMahan. She's a criminal defense attorney and former prosecutor. Ashley, during the break, we were talking about the highs and lows of the trial. It's been a week now. 33 witnesses from the state, no witnesses presented from the defense. Put your prosecutor hat on. What do you think was a win for the prosecution?
Okay, so clearly the prosecution, I mean, you've got, the optics on this are amazing for the prosecution.
For sure.
I mean, you know, you have a defendant with face tattoos that is sitting there, and I don't care how much you say that the jury is just supposed to regard the facts, just supposed to regard the evidence that they see. They are making a judgment call, and they are judging a book by its cover as soon as they meet whoever the defendant is, you know, and that's an uphill battle for every defense attorney.
Yeah, it is.
You know, that we're human beings, and that's who's going to come back with a verdict in this case, and I think that's what they did. I think the great thing that they did was they showed him saying, I loved baby Kalia.
You thought that was a moment for the state?
I think that was a moment that stuck in jurors' mind that I don't even think the state or the defense realized was going to be so pivotal until the end of this trial.
Well, okay, well, see, that's the thing. The second I heard that, and he corrected himself, I was thinking, well, all they have to do is basically clean that up by saying he lost hope. right, in finding his daughter alive. Some would say, well, he lost hope within 3 hours, but we don't know what it's like to, have a baby missing. So I don't, at least. That moment wasn't as pivotal for me, especially because he did make statements about the baby that was in present tense, right?
Right.
What did you think about the defense not presenting any evidence? So you had a week long of evidence presented by the state, and then the weekend, and then Monday came around, the state rested, and then the defense said nothing. Did they have a missed opportunity? Put your defense hat on.
I absolutely think there's a huge missed opportunity here. So as a defense attorney, you oftentimes don't want to put your own client on the stand.
No.
And that's because, they may have a checkered past and that criminal history is coming in. At the very least, they should have brought in an expert witness to testify about battered women syndrome and to testify about the psychological effect that McNabb could have on Courtney. I mean, at the very least for her case, I think that was a huge missed opportunity on the defense side, and that they really didn't explain to the jury that this is a cycle of abuse and that it's not just that, she's being an irresponsible mother, but that she's being manipulated as well. At least if I were her defense attorney, that would have been my argument.
They did miss opportunities to hone in on the abuse, especially with the state's witness, to cross-examine. They didn't really get into that like they should have. But Brian Frost, who is Courtney Bell's attorney, spoke with Arsima Iyer, and she asked them about why they didn't present any experts, especially when it comes to the battered women syndrome. And he made an interesting point. He said he's worked with Layla Zahn for years. He knows her style. He was afraid that putting an expert on the stand, she would have flipped them, concede to certain things that, were bad for the defense. So he made a judgment call on that, and thought it was just enough through evidence, through the other witnesses, through their testimony, having seen bruises on Courtney, having, Chris McNabb at some point admit to hitting her, that was enough. But I agree with you. I would have at least tried, at least in the sentencing portion, at least there, but nothing was presented again. What did you think about the two being tried together? I had an issue with that. Brian Frost had an issue with that, Courtney Bell's attorney, but Christopher McNabb's attorney didn't. And he should have, right?
I absolutely think he should have. Although I think if, you've got Courtney Bell and Christopher McNabb sitting next to each other, I think Courtney Bell looks fantastic as she's being tried alongside McNabb.
Yeah.
Simply because she's just, nobody looks great in this trial, but she at least looks better compared to him.
Yeah.
I would have thought they would have harped more on that and would have played that role up a little bit more. I think if you're McNabb's attorney, you just got to go with the bad facts that you're looking at. You saw him during sentencing. He just can't be reined in.
He can't. He can't be reined in. Ashley McMahan, thank you so much for the insight.
Thank you.
All right, we're going to take a quick break. Stick around. There's still more to come right here on CourtTV Live.
A guy who was very competitive. He played for 10 years in the NFL, had an immense amount of success, had the ultimate American dream, felt like he had it all.
Kellen Winslow Jr. pleaded not guilty to kidnapping two homeless women. The former NFL player reportedly lured them into his Hummer and raped them.
If he's convicted on all counts, he's facing multiple life sentences.
The allegation is he sexually assaulted the alleged victims at the same time period.
He threatened to kill her. He told her that if she screamed, he would murder her.
The notoriety, the money, his wealth and his fame, all of that is at risk now.
It's a money grab, unfortunately. That's the society we live in now.
We're talking about a kidnapping and a forcible rape of strangers of older women.
Because I don't care who's going to watch, I'm going to kill you. I told him to stop.
Her credibility is suspect. Mr. Winslow has every interest in attempting to prevent and dissuade these victims from testifying.
You immediately knew that this was something that people were going to pay attention to.
Any words today about court?
No, all the facts will come out.
It appears as though he was attempting to be able to destroy potential evidence.
I just thought he was going to shoot me or something. I don't know.
Winslow Jr. could face life in prison.
He knows walking in and out of courtroom, the eyes are on him.
To the people that know me out there, they know who I am, and I'm an innocent guy. I'm an innocent man.
Welcome back to CourtTV Live. I'm Yodite Tewolde. Chris McNabb and Courtney Bell were found guilty in the death of their 2-week-old daughter. We covered this trial from gavel to gavel. Here's a recap of the road to justice for baby Kalia.
My 2-week-old is not in her sleeper. Her package is on the floor.
Man, I want my kid, man.
Did you actually see him leave?
Yes.
To go look for the baby?
Y'all got the wrong idea.
Courtney was having a hard time. She wanted to get high.
That baby girl deserved more than not a duffel bag in the woods.
Do you have any idea what could have caused that sort of trauma?
A very hard force.
That guy that his baby was found dead is in the Chevron.
I could hear people in the car.
He jumped out of the car, but I told him to get out of the car also.
And I heard someone tell Chris to run.
And he goes, the cops are on my trail.
They abandoned them youngers yesterday.
The evidence will show that just 14 days later, her father, Christopher Michael McNabb, ended her life so abruptly.
Count 1, murder in the 2nd degree. Count 2, cruelty to children in the 2nd degree. And count 3, contributing to the deprivation of a minor.
And one of the most interesting things was how the bodies were disposed of. Wrapped in items, Casey, blanket, trash bags. This young lady in the duffel bag, and they were all disposed of in a wooded area close to home.
I feel like the story's changed.
Mr. McNabb's house smoking. What were y'all smoking?
Man.
Smoked a blunt before we left.
Yes, got on some blue camouflage shorts.
And did you find blue camouflage boxer shorts inside of the drawstring bag with baby Kalia?
We did.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time.
Y'all know I didn't do this.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty.
All right, still with me is criminal defense attorney Ashley McMahan. All right, Ashley, that was a lot to unpack, yes. But there's so much more in between that we should talk about. We should talk about some of the witnesses that the state called.
Yes.
A lot of them were family members of Courtney and Chris, which could be concerning as a prosecutor, right? Mm-hmm. That they could be combative, hostile witnesses. We've seen a few of them. But for the most part, very, very credible. And one that really stands out for me is Shane Kidd. What did you think about his testimony?
Absolutely. I thought he admitted to he was cool, calm, and collected. And for the fact that he was being basically accused by the defense of, being somebody who came in and could have murdered baby Kalia.
McNabb, right, by McNabb's attorney.
By McNabb's attorney, yes, correct. I mean, he's known McNabb since he was, 7 years old or childhood or something like that. And for him to come in and testify as calmly as he did, just to no, here's the facts, here's what happened. He admitted to bad facts. He admitted, hey, yes, I am a drug user. I have used drugs with McNabb, and he did even say that he was a doting father, that McNabb was a doting father. I mean, that's crazy to me. If my best friend had accused me of potentially murdering their child while they're on trial.
For no reason.
Oh, I don't know that I would be that calm and collected. And I think the jury saw that and they found him extremely credible because of that.
I know I did. And just to remind our viewers, Shane Kidd is one of the individuals that McNabb, Chris, blamed or suspected of doing this to his daughter or killing his daughter. And so the state brought him on the stand to obviously refute that. He was good in some parts for McNabb. He called him a doting dad, proud dad. And in some respects, I mean, his testimony was damning for him because he actually did testify to the abuse that he saw at the hands of Chris to Courtney. And we have a clip, if we could roll that.
Were you ever in the presence when Mr. McNabb made an assault upon Ms. Bell?
Yes.
Tell us about that.
I was at Missy Davis's apartment at the, above the trailer park. Anyways, Chris come up there and said that him and Courtney had just got into a fight. And he stayed up there for a minute and he said he was going back home. I told him I'd walk with him. Anyways, when we got back down there, he walked in and they started arguing again and he jumped on her and started hitting her.
What did you say or do about that?
I told him, enough was enough, come on. Leave her alone.
Now, was there another occasion when you and Mr. McNabb were trying to leave in a car.
Yes.
Tell the jury about that.
We were trying to leave. I was in Chimmy's mom's car, Cindy's car. Anyways, I stopped by over there, and Chris was wanting to go with me. And Courtney didn't want him to leave, and she kept leaning against the car, standing in the way. And he finally flipped out and jumped out of the car and knocked her down. And then jumped in the car, and he wanted me to take off, but I didn't really take. I left, but I didn't really take off the way he wanted me to. It was like he was telling me to, smash out. But hell, I felt bad for her.
Do you know whether that she was pregnant or she had the child already?
I want to say she was still pregnant.
Now,
she might not have been.
All right. So credible.
Yes.
And he described more than one instance.
Exactly. And what he's saying, he's using phrases like jumping on her. She might have still been pregnant. He had to say enough's enough. She wanted to leave. I'm amazed, just absolutely amazed, re-listening to this testimony that there wasn't more from Courtney Bell's attorney about the abuse.
Extrapolate that info,
yes.
like hone in on that, highlight that.
You could even have brought it out, so much more, even if just in cross-examination of that witness.
Yeah, especially knowing that you're not going to call anybody on your end.
Right.
Okay, so another witness that I found very credible was Craig Weatherford. He was the inmate who was locked up on possession of marijuana and a probation violation. We don't know what that violation was, but very credible. He talked about when baby Kalia was missing, him and his fiance went out with the search team to look for her while Courtney and Chris wanted to get high, which was really interesting. He started to describe sort of a transition from being a support system for them two, and then having this feeling, this really eerie feeling about Christopher McNabb. And we have a clip of that. We can roll that.
I don't remember what I said, but I was insinuating that, pretty much I wasn't trying to say it like that, 'cause I wasn't trying to start nothing, but I had to get away from him. We had to take him somewhere to do something. Chris was my best friend at times, and me and him was close. And he told me, he was like, Craig, I can't believe out of anybody you would think I killed the baby.
Was there any reason for you to believe at that time the baby was not alive?
No, ma'am. I just woke up with an eerie feeling.
More than one person had that feeling.
Yes.
He's had that same sort of response to more than one person. Chris, that is. I can't believe you think I did it. He's said that on more than one occasion to people that are close to him, who had this feeling that he had something to do with it. He was very, very credible and damning for him, for Chris McNabb.
Here's the thing with anytime you have a very good friend of the defendant and they're both in jail together, and you have what is kind of considered like a jailbird snitch, right? They may be getting something. It's usually very hard to establish credibility with that type of witness, especially for the state.
Yeah.
That was not a problem in this case.
Because there was no deals.
No.
There was no deals that were made.
No deals, and you could see the emotion on his face. I mean, I thought it really came through, and I bet in person, being a juror sitting there and being so close to him, watching the emotion on his face when he's talking about that feeling that he had, I mean, it was just undeniable that something was amiss here.
He looked uncomfortable.
He looked very uncomfortable.
What did you think of Pam Hamby? That's someone I haven't really talked about very much. Courtney's mother. It almost, she was such a, I don't think she made a difference to Courtney's case, but you can see the dysfunction. Actually, I take that back. She did make a difference to me for Courtney's case, because you saw the product, the end product of having a parent like her, and Courtney, and where she is right now, right? Her mom was on the stand talking about she smoked blunts. Yeah. She talked about, there was an implication that possibly her and her nephew, Chris, I mean, this was a very incestuous, it was disgusting, but they might have had an illicit sort of relationship, inappropriate, that she had. Now I felt bad for her. The defense attorney, Brian Frost, said, how many kids do you have? I believe she said 7. And he asked, with how many different fathers? And she said 5. I felt bad for Courtney. I'm like, this is your mom? We have a clip. Let's watch that real quick and then we can talk.
Well, you're actually closer to Chris, aren't you?
No.
Didn't y'all have a secret Facebook account so that you could go behind my client's back?
He had secret Facebook accounts. to keep from Courtney to talk to people, but it wasn't just me and him.
But y'all got together on certain occasions and
No.
had little.
Absolutely not.
Y'all never had any.
No.
Okay, so she may deny it, but the fact that you even have to question her mother.
Exactly.
This is how Courtney grew up.
Yes, and even Judge Ott did kind of allude to this while he was talking to Courtney during sentencing. He was saying, you know, look, this is not how a mother behaves. And he mentioned something like where he said, you know, I know you may not have even a reasonable example of how a mother should behave.
Yeah.
And I think he was alluding exactly to this testimony of her mom. Because
It's a
can
repetitive
you imagine?
cycle. Repetitive cycle.
Absolutely.
Ashley McMahan, always a pleasure. Thank you so much.